In this video, I'll be explaining the first element of a contract formation, and that is the offer. So what is an offer? Legally, an offer is defined as a promise that's made by the offeror to be bound to perform an action or to abstain from performing an action. And the party that whose offer is made to, that's referred to as the offeree. And the offeree can accept or reject the offer. Now, legally, the offer has to be clear, and it has to be communicated in a clear way for the offeree to be able to accept or reject it. So legally, you can't have a valid offer that's accepted by offeree if the offer hasn't been communicated clearly to the offeree. A critical case when it comes to studying the principle of the main principles of a valid offer is this case that you see in front of you. And that's Carlo and Carbolic Smoke Ball Company. That's a pretty old English case, 1892. It's an important case because it refers to two main things. Number one, what constitutes an offer, and number two, it focuses specifically on unilateral offers. So unilateral offers are offers that are made to the whole world rather than bilateral offers where it's between two parties. So in this case, it was an ad that was published by this company, Carbolic Smoke Ball, and they had this remedy for the flu. They claimed that they have a remedy for the flu, and if you were to use their smoke ball, you wouldn't get the flu. However, Mrs. Carlell, she used that. She used the smoke ball, and she still got the flu. And in the ad, it was specified that if you were to get the flu after using the smoke ball, you'd get a payment of £100. And so the main issue in the court was whether the ad published by the company did it constitute an offer, and the court said it was an offer. It was a unilateral offer, and the acceptance of that offer by Miss Carlyle was through the action that she did. So she performed the act that was specified, and that she used the smoke ball. She still got the flu, and hence was she was eligible to receive that £100 payment. However, what's more important for us in construction is this concept of invitation to treat. It's important because we deal with a lot of tenders in construction. We have a lot of tenders, and a tender, a lot of people confuse that for an offer. A tender is not an offer; it is an invitation to trade. Basically, an invitation to trade is where you ask others to make an offer. So it's a request for others to make an offer rather than it being an explicit offer. Another example is in an auction. So an auctioneer would be making an invitation to treat rather than an offer. So people would be invited to to submit prices, and then it's up to the auctioneer whether they accept or reject that price. The authority case when it comes to invitation to treat is Spencer and Harding. Now the case is basically we had a company, Harding. They issued a tender for the sale of shares of the company, and Spencer was the highest bidder, but still didn't get the shares. So the issue was whether that invitation to treat, whether the tender was an offer or not. And of course, the court said that it was an invitation to treat, wasn't an offer. So Harding wasn't obliged to accept, Spencer's bid, just because, that just because Spencer thought that it was an offer. It wasn't an offer. It was an invitation to trade, and it was up to Harding to decide whether they would accept or reject the offers that were made to it. So we talked about, tenders being a call for a tender being an invitation to trade. However, within that process itself, within the tendering process itself, there is this contract that's implied by the law that forms. So there is this offer that's made, it's implied, and that is the tender process contract. What's that tender process contract? Tender process contract is where um, it's where people or the party that's issuing the tender agrees or offers to fairly examine all the tender submissions that are made. So this is a contract. It's specified in a lot of public tenders, a lot of the regulations. So for instance, if you look at AS 4120, there are There are detailed express terms that highlight the conduct of the parties during the tender, and where that tender process contract is mentioned. There are these two common law cases as well, and where they highlight that the conduct in the tender process has to be in good faith, and the engagement is in fair dealings, where the party that's issuing that tender agrees to fairly assess all submissions. So that's the only sort of offer or the agreement or the contract that's implied by law when you issue out a tender, when you call for a tender. You are agreeing to abide by this tender process contract where you fairly assess the submissions that are made. However, the tender process itself, as I said, the call for a tender is an invitation to treat. It's not an offer. It's merely you're requesting people to make submissions, and then in this case, they become the offeror, and you're the offeree that can accept or reject submissions that are made to you. Some important question that we have to understand: what is not an offer? Okay, so as I said, an invitation to treat is not an offer. So just because there's a tender, just because you submit your proposal, it doesn't mean that you're accepting the offer, because there's no offer. It's an invitation to treat. Another example would be if an owner of a property indicates that they are interested to sell their property at a particular price. That is not an offer. They're interested, and that's basically considered as an invitation to treat. So they're inviting people to submit offers to them. The display of goods as well for sale. So if I was selling, demolition equipment in a shop, the display of equipment itself is not an offer. It's an invitation to treat. And as this case highlights that. And another important question is, if there's an offer that's made by the offeror, can that offer be revoked? Generally speaking, yes, as long as the revocation takes place before the acceptance. And for the offeror to revoke their offer, it has to be communicated clearly that they're revoking the offer. So I'd mentioned that generally, yes, the offeror can revoke the offer. However, there are certain situations where the law or where the courts would impose what we refer to as estoppel. So the law of estoppel is where the court would prevent an offeror from revoking their offer. And these are cases where the offeree had, accepted the offer and had acted in a way where it was to their own detriment. So they relied on the offer that was made, and they acted in a way, so they performed conduct. So let's say, for example, there was an offer for building a house, and the offeree had started already building that house, so they acted to their own detriment. So in the court, the court can apply that law of estoppel, and they can tell the offerer, you know what, you can't go back on your offer, even though there hasn't been a clear, explicit acceptance by the offeree. But given that the offeree had acted to their own detriment, so they relied on the offer that was made by the offeror would be stopped from revoking that offer. So that's what the law of estoppel means. And finally, can an estimate be an offer? So, we in construction, we deal with a lot of quotations that are submitted as estimates for quoting different projects or different parts of a project. So can these estimates be considered as an offer? Traditionally, the courts have allowed estimates in the common law to be accepted as offers, and this is one case that highlights this. However, in recent cases, this hasn't been what was implemented by the court. So in this particular case in 2006, a recent case in Australia, the court found that the estimate was merely an estimate and it couldn't be regarded as an offer.